Hello, everyone. I'm going to try something new. I'm going to get off the digital marketing topic for a little bit because I want to introduce you guys to some of my clients. And I'm going to start off with one young lady who's a superstar. She's a great client of mine. She's doing a lot of stuff out there, and she's an attorney. And I want her to just introduce her business to you guys so that you can guys learn a little bit about protecting your business. Without further ado, enjoy the show.
Hello, and welcome to Marketing Solutions for Local Businesses, the podcast where you will discover all the latest and greatest digital marketing tools, tips, and strategies you will need to implement in order to stay ahead of your competition. If you are not getting the results you are looking for from your digital marketing efforts, this is the podcast for you. And now, here's the host of our show, the local business guy himself, Frank Deming.
Hello, everyone. This is Frank Deming, the local business guy, and welcome to another episode of Marketing Solutions for Local Businesses. Happy Wednesday. Happy Hump Day, everyone. I hope you guys are having a rockin' week thus far. Today, I have the privilege, as I said in the pre-intro, of introducing you to not only a client of mine, but she's also a friend and happens to be a wonderful lawyer. I'm not going to talk to you. I'm not going to divulge what law she practices. I'll let her do that. But I want to introduce you to the great Crystal Lawson. How are you doing? And welcome to the show, Crystal.
Thank you. Thank you for having me. That's a wonderful introduction.
All right. So I know you very, very, very well, but my audience does not. Can you please tell me who are you and what do you do?
All right. My name is Crystal Lawson. I am a trademark attorney, and I specialize in helping entrepreneurs get federal trademarks for their brands so that they can focus on their family and making money, and I'll handle the rest.
Oh, okay. So tell us a little bit about that. I particularly do not know a lot about federal trademark. And I tried it myself one time. I actually dumped it because it took too long and no one, I wanted to trademark the term 7 steps to recession proofing your business because that's part of the things that I wanted to trademark the 7 steps that I use. And they gave me such a hard time. So anyway, before we get into that whole story, this is about you. So I wanted to find out, why would someone trademark and what is it in the first place?
Okay. All right. I will address where you're concerned, though, because that's a very interesting topic. So a trademark, if we want to get legal about it, is a source identifier. So I like to tell people that your LLC or your corporation, that's the person, and you trademark the different clothes that person wears. So you wear a different outfit to church, then you wear it to the club, then you wear it to the grocery store. Those 3 different outfits are the different ways that you present yourself to the public. Mm-hmm. Those different outfits are your trademarkable elements. So for most people, for most business owners, that's going to be your business name, a brand name, a product name. It's going to be a logo or some type of an image that you associate with your brand, or it's going to be a slogan, tagline, or some sort of short sentence that you associate with your brand. Now, the reason to get a trademark, well, there's many.
But I was just about to ask that.
There are many reasons. There's many reasons, but I would say the most important reason to get a federal trademark for your brand is if you don't do it, someone else will. There are so many of us. There's like a couple billion of us here in the United States alone, right? And it is without a doubt, multiple of us are going to have the same idea. We're going to come up with the same name for the same type of business, the same name for the same type of a product, right? Mm-hmm. And out of all of us who are sharing that same name, that same product, living in different states, right? Mm-hmm. The first one of us to get a federal trademark is the one that has the upper hand. And that person, if they so choose, can enforce their trademark and go state by state and force you to either rebrand or stop using the name, close down your business. And if you don't follow suit, you can get a trademark infringement lawsuit. So there's a lot of details there that I'm leaving out for the purpose of simplicity, but it is to your benefit if you really care about your business. If it's something that is not a 2-3 year business, but it is a lifetime commitment, something that you have built from the ground up, that you anticipate passing down to your children, or you anticipate sometime retiring and actually selling this company, then it benefits you to have a trademark, because then you're going to protect the brand that you have built, that customer association that you have spent your time building when it comes to your name, your logo, and your slogan.
All right, so you said a mouthful, so I have a whole mouthful of I have a mouthful of questions.
Of course.
Due to that, what you just said. So all right, so first of all, you said federal trademark, and you were specific in saying federal. So does that mean if you have a federal trademark, does that mean that if I'm in Texas, I'm protected even if I'm living in New Jersey?
Yes, but I want to answer that a little more specifically.
Okay.
So it doesn't matter what state you're living in when you get your federal trademark, and it doesn't matter what state you move to. That federal trademark is for all 50 states and U.S. territories. And what that allows you to do is to enforce your brand, enforce your trademark. So you have the obligation to make sure that you are the only one using your name brand to sell your types of goods and services. And if you see people that are infringing is our fancy word of saying stealing your trademark to sell their own goods, then that trademark that you have, that federal trademark, gives you the right to pursue anyone in any state or any U.S. territory.
Okay. All right. Yeah, that's what I wanted to know. So basically, it does protect me for that. Now, it doesn't stop them from wanting to go after, because I remember going, and I wanted to. The reason I'm phrasing it this way is I had the privilege of hearing you speak at an event where you gave some examples. So I would love for you to share that piece, because that was interesting. How even if you do the federal trademark, people can still try to steal your brand. Can you talk about that a little bit?
Yes. So I think you're referring to the Kim K story.
Yes.
That one I have to check in on, and I haven't checked in on what's going on. So I'm going to try to make the story as brief as possible. Essentially, there is a small business owned by a young Black woman in Brooklyn. I believe she's had this business for roughly 3 years. And the name of the business is Skin. It's spelled Skin, SKNN, and then there's a plus sign. So I think either they say Skin or Skin Plus. Kim Kardashian, a person who is a celebrity and who is extremely wealthy and has access to all the resources you need to do a thorough clearance search for the trademark. That means make sure there's no one else using this name before you go register it.
Yeah.
Obviously, found out about this woman and went and registered her mark anyway. Kim Kardashian has a brand that she just started promoting, I want to say in March, very early in this year, a new brand called Skin, SKN or SKKN. And as you can see, her brand, Skin, SKKN, and the small business owner brands, Skin, SKNN plus, are very similar.
Yes.
You could definitely confuse the two brands for each other. So in the trademark world, that's called confusingly similar. And we don't allow more than one owner to register the same type of, the same name or same logo or same slogan, because it's going to confuse people. And when people are confused, they don't purchase, right? So it's in the interest of consumers to limit the amount of people that can share the same name, the same logo, the same slogan. So Kim Kardashian obviously has a team of trademark attorneys, probably found out, we don't know. She said she didn't know, but she probably found out about the Brooklynites and decided to file her trademark anyway. I'm assuming they didn't reveal this, but I'm assuming that they had some type of conversation before this, because the Brooklynite filed her trademark application, let's say like on the 13th, and then Kim Kardashian filed her trademark application maybe 2 or 3 days later. So all of this was strategic. So what I think happened is that Kim K found out about this Brooklynite, approached her and tried to bulldozer her by either offering her money or something to get her to stop using the name so that Kim can have all the rights to the name everywhere. And the woman refused, hired a big shot trademark attorney, and they raced to be first to file. So because that Brooklynite got herself a trademark attorney and is first to file, she has priority and she will likely make out very well in this case. If she didn't file first, and you see they're days apart, which shows you there was a race to go file. If she didn't file first, she would have been in a severely worse position because Kim would have had priority. So not only would Kim have priority, but that coupled with her money and her status would have been enough to really just shut down this woman's company. Unless she had the money to really do a long, stretched out trademark infringement lawsuit.
Okay.
So right now it's pending. We don't know how it's what's gonna happen, but I think the Brooklynite is probably gonna make out well in this case.
So I'm glad you reiterated that, because I totally messed it up. I thought she already had the trademark. She raced on the trademark when she found out that Kim was doing it. So all right, so that spurs on another question. You see, you keep saying stuff. So let's just say if she did already have her trademark set, she had it already trademarked. Can Kim do anything at that point?
Well, the thing about trademarks is there's a lot of options and you have to be really strategic. So if this woman, the Brooklynite, I'm calling her that because I don't remember her name, but if she had already had a registered trademark, because right now she has a pending trademark. If she had a registered trademark, then that would give her an automatic presumption of ownership. So she could immediately take Kim Kardashian to court, and Kim would be forced to prove that she was the first one to use this term, which we all know would not fly because Kim is the one that has been posting on Instagram during the winter. Hey, I'm coming out with a new line. I came up with this new name. So we know this is new. Meanwhile, the Brooklynite has been using this particular name for at least 3 years.
Yeah.
Yes.
Okay.
So
I mean that's a good argument for trademarking right there. So I love that. So I that's why I wanted you to bring that up here to the audience, because I thought that was fascinating. Although I got it wrong, but still I was able to understand a little bit better now, and I think the audience understands the importance. So what are good things? So let's change shifts a little, shift gears. Shift gears. There you go. It's too early in the morning. Anyway, let's shift gears a little bit and talk a little bit about what can be trademarked. I know you talked about logos and all that stuff. Well, give us some other. First of all, what can be trademarked, and what's another thing are there any businesses out there that probably don't even need a trademark?
Okay, good questions. I'll start with the first one. What can be trademarked? Anything that you can prove to the trademark office that customers identify you as. So virtually anything can be trademarked, but most of the time it's a name, it's a logo, it's a slogan. You can also trademark colors. You can trademark sounds. You can trademark acronyms. You can trademark different fonts that you write your name in. So even if you don't have a logo per se, but Instagram does this. Instagram has a script version of their name and a plain text version of their name. They have both registered. So essentially, if you have a product or a service And there is a way in which your customers identify you that is provable, right? Provable by showing up on your website header and on your business cards and on labels on your products and awning in front of your business fronts, right? It has to be provable that your customers see this thing or hear this thing or smell this thing. You trademark a smell and think of you. So for instance, Play-Doh has a trademark for their scent. It's a vanilla musk scent. And I know the minute I say the Play-Doh smell, I know everyone knows what I'm talking about. We know
they go
that.
Right. Smell. Yeah. They go right back to that. The senses, your senses go through it. Yes.
Exactly. And they were able to, it wasn't easy, but they were able to do market research and gather that information and present it to the trademark office and say, hey, we did all these surveys. We did all this market research. Look at how many people smelled the smell and said, oh, that's Play-Doh. And they got their trademark. So anything that identifies your business that you are able to prove others see you as, that can be trademarked. I forgot your second question.
Are there any businesses out there that you don't foresee needing a trademark at all?
No, I don't see
everything. Okay.
Yeah, I don't see a reason not to get a trademark. There are businesses that it would be difficult to get a trademark for.
So let's talk about that.
Yes.
Because I want to go back to my original question with my process. I wanted to trademark this process. And of course, back then I didn't know who you were. I was still in DC back then and yada, yada, yada. So I have this process that I thought that it was the greatest thing since sliced bread. So I wanted to trademark it because I wanted to protect it. I didn't want anybody else to use it. And these people, I don't know if they laughed at me or if my request went to the bottom of the pile. But every time I would call them, they didn't know how to do it, how to keep reopening the case, and I just got tired. They wore me down. I just gave it up.
Okay. Well, if you were trying to trademark a process, you were in the wrong practice area. You don't trademark a process. You patent a process. That's that number one. That's the number one step right there. Patent protection is a different type of intellectual property, right? So all of these things we're talking about are intellectual property, which I like to say is the fruit of your mind, right? The things that people create that come out of their brains and express themselves in the world. So trademark, again, protects branding, right? The way others see your business. Patents protect systems, procedures, processes, inventions. I mean, there's a patent for how to swing. Seriously, how to swing in a swing. There is a patent.
Swing a bat and swing a golf club? What do you mean?
Sit in a swing and swing.
Oh, swinging in the okay. No, I wasn't sure what you meant. Okay, gotcha.
The playground.
Really?
So, yes, there is. Yes. I have a very good friend, Dorothy Smith. I'm shouting you out right now. She is an awesome patent attorney. She's based in Florida, and she's the one who told me this. And my mind was blown. So patents are for systems, procedures, processes, improvements on old innovations, right? Old inventions, and also new inventions, but you have to prove that your invention is new, which is difficult to do. And formulas, right? People who mix up different types of scents, different types of food recipes, those all fall under patent. So I think the initial problem might have been you were in the wrong place. Yes.
And no one told me. Well, I wasn't working with an attorney anyway. But I don't know. I may give it a shot again. But I mean, I've seen very similar processes used now. So I think it's just gonna be not even worth it. But it's interesting.
I don't know. You should book a consultation with Dorothy. She'll tell you. She'll let you know whether it's worth it or not.
Oh, you don't do that. So that patent and trademark aren't similar?
No, they are not. They're two completely different fields.
Gotcha. Oh, I'll book a consultation.
Some attorneys do both. Some do both. But because patents are, in order to do patent, what is called when you register a patent is called patent prosecution, right? So in order to practice patent prosecution, you must have an engineering, mathematics, or science degree, which I do not.
Gotcha.
Yeah, so I can do patent litigation. I can go to court and fight over a patent, but I just can't help someone actually secure one. It involves a lot of technical parts that I just wouldn't be able to do.
Okay. Well, okay. Well, that's cool. That helps me. All right. So let's go back to some other things. Like I want to find out who is it that is. I understand that everything can be trademarked and everything, but there's got to be a sweet spot. There's got to be something that you have to, without a doubt, have to trademark, else you're looking into some problems. Can you give us some indication on what that is?
Okay, the sweet spot. All right. So we have what we call the spectrum of distinction, right? So a spectrum, right? Goes from low to high. On this spectrum are the levels of distinction, which means the levels of, how do I put it? We want people to be creative, right? The trademark world wants people to be creative. So the more creative you are, the more likely you are to get a trademark, right? The more trademarkable that brand element is, right? So that spectrum, instead of calling it distinctiveness, let's say it's a spectrum of creativeness, where on the low end it's the most basic, a non-creative concept, and at the high end it's the most outrageously creative concept, right? So on the low end we have generic, right? Generic terms, phrases, logos. Usually it's terms. It usually has to do with words. Generic words are not trademarkable because we don't want people having a monopoly over words that everyone has to use to describe their businesses. For instance, the word business, company, LLC, the words boutique, shop, right? House, world, universe. We don't want people to trademark those types of words because other people need them to describe their business. If someone had a monopoly on the word world, think of how catastrophic that would be. They'd be issuing cease and desist letters left and right.
But let me stop you there for 1 second.
Okay.
Let me ask you this: can you trademark a different spelling of the word, like a spin on the word?
No.
Let's. Oh, really?
Just no. I'll get to it. I will get to that. And
all right, gotcha.
But I'll get to that. So generic. So my best example is I'm so sorry, the coffee house, but if you have a coffee shop that is called the coffee house or the coffee shop, you cannot trademark that name because you are describing exactly what that business is. So that's the lowest end of trademark. Next up is descriptive. Again, descriptive, you can't trademark descriptive words. So instead of being called the coffee shop, maybe it's called cold brew, right? It's describing a type of coffee that is served in the coffee shop. That still is not trademarkable because you are descriptive, right? We want you to prove that you have created an association between your business and the customers. Like you did some type of work to make customers see this name and think of you, right? Anybody can call their coffee shop cold brew, can call their coffee shop coffee house, but we want to reward creativity. So that's when you get into the sweet spot. The sweet spot is where most people are. It's called suggestive, right? Suggestive, it takes a little bit more work for the consumer to understand the link between your name and the business. So a good example of that would be a refrigerator brand called Penguin, right? You have to take a little minute and you're like, oh, penguins live in the cold, refrigerators are cold. Okay, I get it, right? That's a good example of something that is suggestive and that has a good chance of being trademarked.
What's funny? You know what's funny about that? That goes against all marketing.
It does.
practices.
It does.
In marketing, you want to be as clear as day as what you do.
It
But
does.
with trademark, you want to be creative outside of that. And
It does.
I'm sorry for the interruption.
There's actually I haven't watched it yet, but there was actually a conversation about that, about the tension between marketing and trademark law. It's such a fine line. There's a tension because, as you said, marketing, you want to tell that the customer needs to know what they're getting ahead of time to make it easier for them to make that purchase. But trademark law says that's too easy. Why should we protect that?
That's quite interesting. Okay.
Yeah. So as you move up on the spectrum, you get more and more protection. Your protection's stronger and stronger, and you're more and more likely to get trademarked. So we have arbitrary, which is when you assign a word that has nothing to do with your business, right? You name your business something that has nothing to do with your business. Apple computers. Yeah. Apples have nothing to do with computers. What's another one I could think of? I can't think of one right now, but there's plenty that are in your world that you can think of right now. Like, oh, okay, that really has nothing to do with what I'm buying, but I know that
you associate it with it now because
exactly. And then the highest form of protection is when you invent something. You invent a completely new word, you invent a completely new language. Kodak means absolutely nothing. I believe it's an acronym. But I don't know what it stands for. And that's to sell photography equipment and software.
It's kind of like Uber.
Uber, there you go. Uber would be more so suggestive because Uber has the root of something that's new and fast. So that would be in the suggestive category because it's a new company. It's a new style of traveling, right? You could argue that it's arbitrary because Uber is a real word. Like you can say this is an Uber style. It's kind of European word, but Uber would be more so suggestive or maybe arbitrary.
Because I know Lyft is definitely because they play on the word.
Yes, exactly. They're giving you a lift.
Yeah. But I would think Uber wouldn't, but I could see the argument why. Yeah. Interesting. See, that's why you need an attorney like, say, Crystal Lawson to explain all of this stuff to you, because that, to me, as business owners, we get bombarded with so many different things, and then we work so hard on building our brand or whatever, and then someone takes it from you. That's terrible. So I would say whatever you can protect it, especially if you've worked hard on doing it.
It's really tough to get those phone calls from people where they've either have a situation where they filed a trademark themselves and they have someone else coming after them. I have someone that called me because Shakira is coming after her. She's almost done registering her trademark.
Shakira.
Yep, Shakira.
So like big name people are coming after you.
Yes. She filed her trademark. She's in the last step of the trademark, which is when they publish your approval. In order for they give you 30 days for anyone to come forward and challenge your trademark. And Shakira herself came forward and challenged the trademark. So that's an unfortunate situation, but it shows you that it could happen to anyone. I have people leaving comments on my Facebook page saying, "Oh, I did my trademark myself. It's very easy." And it's like, you can do it, but it's very risky. It's very, very risky because what if you end up with Shakira sending you a cease and desist and telling you to shut down your business?
Yeah, that would bother me. So, I have another question that just the whole Shakira thing just made me think about something here.
Hard not to do her voice. I really want to do her voice, but I'm not doing it.
So, how long does this take? Like, so let's say I go, hey, Crystal, I want to trademark my, I want to trademark my voice, my radio voice,
Oh,
marketing solutions for local businesses. No, I'm just joking. Let's say, let's say I want to trademark something. I come to you, we sign the document, we sign the contract, we go. When am I protected? How long does that take?
okay. So the protection is incremental, if you will, right?
Mm,
So first, I'm going to talk about how long it takes, then I'm going to talk about the protection. So the actual process, it takes a very long time. Well, relatively long time. It takes about 1 year to 1.5 years from when you file your trademark application to when you actually get a decision as to whether or not you've been approved. And that is not fun. So as a business owner, if you were doing it yourself, you'd have the duty to monitor your application. And I don't know if you would really be able to take on that kind of a responsibility on your plate when you're already running a whole business, right? At least one
right.
business. Some people are running multiple, right? So
Multiple,
you,
yeah.
you have a duty to monitor your trademark application, because when they do start reviewing it, they're gonna have questions. The officers are gonna have questions. They're gonna want answers. They're gonna tell you there's defects. They're gonna want you to correct these defects, and you have a certain amount of time to make your corrections. So if you're not paying attention, right, to your emails, if you're not checking up on your trademark application at least once a month, you
Right.
run the risk of abandoning your trademark. That means losing your application is just gone. You lost your application because you did not keep up with the monitoring process and answer all of the notices in the time in which they needed to be answered. So that's another benefit of working with an attorney. It's my job to monitor. It's my job to answer the trademark examining officer's questions. It's my job to respond to formal legal notices that come out from the trademark office, because they sometimes do. So I take all of that responsibility off of your plate.
Okay.
Now I'm trying to go back to your question. How long does it take? And there was another part to the question.
Yeah. So the other part was, so while,
Oh, the spectrum of protection. Yes. So
right.
when you file your application, there's already a level of protection there, right? You're in the system
Yes.
and it's giving public notice that you are in the process of getting a registered trademark. So while your application is pending, you have priority over everybody else that files something similar after your application is filed. So if you filed in January and someone files the same thing in February, your application is looked at first. And if you are approved, then their application is kicked out. Right. Well, first
Even if it's a day after, right? Like, so
even
if
if it's the day after, even if it's the day after, yes.
that's important to know.
Yes, it gives you priority. It gives you priority, and then when you're approved, that's when you kind of get the full benefits of trademark protection, which include the presumption of ownership. Right, when if and when you go to court, you're presumed the owner. It gives you the right to actually now license out that trademark, because now you're technically the owner of it, so you can license the use of that trademark out to other people. If you see other people using your name or your logo or slogan or whatever it is that you've trademarked, instead of trying to force them to rebrand or forcing them to cease and desist, you can try to make some money and license it out to them. So it gives you some options.
Wow, this has all been so great. Tell me something, Crystal. How can people get a hold of you? I'm gonna drop a link in the show notes and everything, but why don't you tell them what your website is and your number, if you want to give out your number. If not, I'll put it on the show notes. But how do people get a hold of you?
All right, you can get a hold of me a lot of different ways. The best way is to send me an email, crystal@lawsonfirmllc.com. That's CRYSTAL at LAWSONFIRMLLC.com. You can also catch me on Instagram at Crystal Lawson ESQ. And you can catch me on Facebook, Lawson Firm LLC. And of course, you can always visit my website, lawsonfirmllc.com.
Oh, that's awesome. Awesome. Now, before I let you go, Crystal, is there anything I didn't ask you that you think would benefit the audience?
Oh gosh. No, I can't think of what people should ask me because there's so much depth to this practice area
Yeah.
that people just surprise me. I get new questions every day. So if you do come up with some new questions, I'd be happy to hop back on the show and answer them. Or if anyone in the audience has a question, definitely drop me a line and I'll do my best to answer it.
Awesome, awesome. Well, thanks a lot, Crystal, for joining Marketing Solutions for Local Businesses. I know this is off the beaten path of what we normally talk about on this show, but I know a lot of people got a lot of value out of it. And I really, really would like to take you up on that offer of coming back. I kind of heard a subtle hint there. So I hope you at some point in 2022 we can re-engage here and help folks out. Because I know that this is an important practice. I didn't know how important it was until I saw the presentation that you had several weeks ago. So I wanted to put you on the show so we can educate the audience on this. So with that, folks, I am going to bid farewell to this episode. This has been Frank Deming, the local business guy, and you've just been blessed by the great Crystal Lawson. Until next week, take care, folks, and bye for now. Peace out.
Thanks for listening to another episode of Marketing Solutions for Local Businesses, the podcast where you will discover all the latest and greatest digital marketing tools, tips, and strategies you will need to implement in order to stay ahead of your competition. Don't forget, any links that were mentioned during the broadcast will be available to you in the show notes, so be sure to grab them while you have the chance. Incidentally, if you have any topics that you would like for us to discuss on the show, be sure to send an email to the email provided in the show notes, or click the Contact Us link and let us know what topic you would like us to help you with, and we'll be sure to add it to our schedule. If you would like for Frank and his team to look at your digital marketing presence and give you a free evaluation, simply click the Request a Free Consultation link in the show notes to get a hold of them. That being said, until our next episode, make it a successful digital marketing day. Peace out.